Welcome to the U.S. Customs and Border Protection's Office of Trade Learning series. The purpose of today's video is to help explain the Enforce and Protect Act, EAPA. The CBP Office of Trade leads America's trade-related security, enforcement, and facilitation activities to protect U.S. lives, businesses, and jobs. The Office of Trade has several offices and programs that provide uniformity and clarity in implementation of CBP's national strategy. One of these offices is the Enforcement Operations Division, EOD. The EOD implements the Enforce and Protect Act, EAPA, and facilitates the EAPA allegations process to protect the U.S. economy from the effects of unfair trade practices and guard against the entry of products that could pose a threat to health and safety. The Trade Facilitation and Trade Enforcement Act, TFTEA, authorized the EAPA program, and CBP implemented EAPA through regulation in August 2016. EAPA allows CBP to investigate whether a company or other entity has evaded anti-dumping and countervailing AD/CVD duties in an on-the-record investigation. EAPA is a multi-party, transparent, administrative proceeding where parties to the investigation can both participate in and learn the outcome of the investigation. Parties to the investigation also have the option to request administrative and judicial reviews of CBP's determination as to evasion. An EAPA allegation is defined as a filing with CBP under Section 165.11 by an interested party that alleges an act of evasion by an importer of AD/CVD orders. The definition of interested parties can be found in 19 CFR Section 165.1. EAPA provided CBP with new authorities to investigate the alleged evasion of AD/CVD orders. The new authorities provide CBP with the ability to protect potential revenue owed to the United States, enforce importer compliance, encourage participation in the investigation, and verify submissions. These new authorities include interim measures, adverse inference, and foreign verification. When filing, allegers must provide their name, contact information, and how they qualify as an interested party. The allegation must also include the name of the importer alleged to be evading, a description of the covered merchandise and the applicable AD/CVD orders, a description of the evasion scheme, and evidence that reasonably suggests evasion. After CBP receives a properly filed allegation from an interested party, it has 15 business days to determine whether to initiate an EAPA investigation. Parties to the investigation will be informed of the initiation and outcome of the investigation. There are set timelines for determining applicability of interim measures to protect the United States from revenue loss. For example, 90 days from initiation of an investigation. If CBP determines there is a reasonable suspicion of evasion, CBP will issue interim measures, thereby extending and suspending entries suspected of AD/CVD evasion, and will start collecting cash deposits for certain entries of merchandise. The investigation will be assigned to a team of CBP experts, including case investigators, import specialists, and regulatory auditors to investigate the allegation from initiation until final determination. For more information on best practices for filing an EAPA allegation, the investigative timeline, and use of the EAPA Allegations Trade Violation Reporting Portal, please visit the EAPA website or contact us through the EAPA inbox.